Hello, everybody. This is John Bruegger again from California Southern University School of Law. Welcome to week 3 of Civil Procedure, Law 5121. This week we're going to continue our look at personal jurisdiction. Last week we talked about the Pennoyer case, the difference between in personam, in rem, and quasi in rem jurisdiction, and then the modern sense of personal jurisdiction, starting with the international shoe case. We discussed specific jurisdiction, where the jurisdiction of the court over the defendant is particular to the nature of the contacts that the defendant has with the forum state. That was the worldwide Volkswagen case, the case of the New York car dealership who was sued in Oklahoma, and the court held that he couldn't be sued in Oklahoma, and there's no contact with the state of Oklahoma. This week we'll be discussing general jurisdiction, which is the power of a court to hear all of the claims against a defendant without limitation to the nature of the defendant's contacts with the state. So, specific jurisdiction is, does the court have jurisdiction over this defendant based on the contacts that the defendant has with the forum state? And then general jurisdiction is, are the defendant's contacts with the state such that the court can hear any and all claims against the defendant, even if they're unrelated to the contact that the defendant has with the state. So just to break this down a little bit more, specific jurisdiction, we looked at the Burger King Corp case. That's the one where the franchisee in Michigan was sued by Burger King in Florida, and even though the franchisee himself didn't go to Florida or have any contacts with Florida, the court held that the contract they entered into for a long period of time, where money was being paid from the franchisee to Burger King in Florida, was sufficient to make the defendant's contacts with Florida confer jurisdiction in the case. Now, that case was the Florida court could exercise jurisdiction to hear the case of the breach of the franchise agreement, which was centered in Florida. So that was specific jurisdiction, specific to the nature of the contacts in that case. In other words, the contract between Burger King and the franchisee. General jurisdiction is different. Let's take an analogous case to Burger King. We'll say that, let's say the franchisee in the Burger King case is in Michigan. A customer comes in and dines at the restaurant, travels to Florida, becomes ill with food poisoning, and then sues the franchisee in Florida for personal injury because of the food poisoning. So while the Burger King case says that Florida has specific jurisdiction because of the nature of the contacts that the franchisee has with Burger King in Florida, the Florida court would not have general jurisdiction over the defendant for purposes of the personal injury lawsuit. So, specific jurisdiction is contact with Florida is the franchise agreement. The court can hear a case in Florida related to the franchise agreement. General jurisdiction, his only contact with Florida is the franchise agreement. So the court cannot hear any other cases against the defendant in Florida that are unrelated to that franchise agreement. So general jurisdiction generally applies to individuals in the state where the individual is domiciled. And domiciled has a specific meaning. It's usually where the person lives and they have an intent to remain there. So if you live in California, you've lived there for a while, you intend to stay in California, California is your state of domicile. Let's say you live in California, or you lived in California, but you decided to go to a school in Nevada. You're living there temporarily, maybe on campus in a dorm. You plan on returning to California after you finish school. California or Nevada is not your domicile. California remains your domicile. So individuals, there's general jurisdiction from the state where you are domiciled. For corporations, the domicile is where the corporation is incorporated, and also the state where the corporation has its principal place of business. So corporations have two states in which they're considered to have general jurisdiction, where the corporation is incorporated, and where they have their principal place of business. And as an example, we'll say Mr. Smith lives in California and has for his entire life. So the California courts have general jurisdiction over him. That's where his domicile is. They can hear any lawsuit brought against Mr. Smith in California. Now let's say Mr. Smith owns a company called Smith Corp, which is incorporated in Delaware and has a principal place of business in Los Angeles, California. So the Delaware and the California courts both have general jurisdiction over Smith Corp because of the fact that it's a corporation and that it is incorporated in one state and has its principal place of business in the other. So let's take a look at the Goodyear Dunlop tire operations case. This case involved a bus accident that occurred in Paris. The tire on the bus blew out, causing an accident that killed 2 children who were from North Carolina. The children's parents brought suit against several defendants in North Carolina. One of them was a Turkish subsidiary of Goodyear. The Turkish subsidiary made tires. The tire that ended up on the bus that blew out was made by this subsidiary. So the courts are looking at the question of whether the foreign subsidiaries of a U.S. parent corporation are amenable to suit in a state court on claims unrelated to any activities of the subsidiaries in the foreign state. So in this case, the Turkish subsidiary, there was no allegation that it had an office or that it conducted business in the foreign state. It had no connections with North Carolina. I think there was some tenuous argument that, well, because the Turkish subsidiary could put the tires out into the general stream of commerce, that it's possible they could end up in North Carolina. But really, in this case, there was no connection at all. So what the plaintiffs were arguing was, yes, there's proper jurisdiction because of Goodyear, and Goodyear's the parent company, and the subsidiary should be held to have jurisdiction in North Carolina. So the court has held that the court may assert general jurisdiction over foreign corporations when their affiliations with the state are so continuous and systematic as to render them essentially at home in the foreign state. And you'll see that phrase at home when you're doing your studying and your reading. So looking again at we'll look at the specific jurisdiction language that we've talked about previously. Specific jurisdiction looks at the nature of the contacts that the defendant has with the foreign state. The defendant must have purposely availed itself of the privilege of conducting activities in the foreign state. The contact must be such that he could reasonably be anticipated being hailed into court there. That's from the Worldwide Volkswagen case. But when looking at general jurisdiction, the court doesn't look at any of these contacts. The court's not looking at what the defendant did in the state and how many contacts they had and whether the defendant could reasonably anticipate being hailed in the court there. All the court looks at is if the defendant is at home in the foreign state. So because there's no way that the Turkish subsidiary could be held to be at home in North Carolina, the court's not looking at any other contacts. The court's not looking at this bogus stream of commerce argument that was posited. So there is no at-home jurisdiction in North Carolina. The foreign company is not in North Carolina. The defective tires and the bus accident did not occur in North Carolina. So there is no general jurisdiction in North Carolina against the foreign subsidiary. Let's look at the Burnham case. In this case, it was a husband and wife who were living in New Jersey, decided to get divorced. The wife moved to California with the children, and they were supposed to agree on how the divorce was going to proceed. The wife filed for divorce in California, and the husband filed for divorce in New Jersey. The husband came out to California to see his children and was personally served with process in California. So the court looked at the issue of whether the 14th Amendment Due Process Clause allows a California court to exercise jurisdiction over a non-resident who's temporarily present in the state for activities not connected with the non-resident's activities in the state. So, in this case, the defendant, the non-resident, he is from New Jersey. He came to California only for the purpose of seeing his children. He did not intend to remain in California, didn't have a domicile in California, and the lawsuit that was being brought against him in California, the divorce, did not have anything to do with his activities in the state. His activities in the state were to see his children. The divorce had nothing to do with him seeing his children. So the court looked at whether this was a proper use, a proper exercise of jurisdiction. And so we see this general rule that a state has jurisdiction over non-residents who are physically present in the state. Now, in this case, the connection is very tenuous. He was only there for a short time, a couple of days, I think, is what the testimony was. But he was personally served within the state. So the court looked in this case at the sufficient minimum contact argument and rejects it. The court states that the Schaefer case we looked at last week requires a sufficient minimum contacts analysis when the jurisdiction is quasi-in rem and unaccompanied by in-state personal service. So in Schaefer, it was quasi-in rem. There was no personal service within the state. And so the court had to look at what other sufficient minimum contacts were present. The purpose of this, and we talked about this last week, was the defendant has to be put on notice. The defendant has to have reasonable notice in the forum state. So the court would look at, is it proper to exercise jurisdiction in this case? In other words, is the defendant going to be properly put on notice that his interests are possibly in jeopardy in this lawsuit? In this case, in the Burnham case, the defendant was physically in California and thus had notice. Assuming the notice was proper, that he had notice of what the action was about and served with the summons and all of that, then the court held that this is proper service. This is a proper exercise of jurisdiction, even though the defendant had no other contacts with California other than just being physically present in the state. That's enough. Justice Brennan, who wrote a concurring opinion, made an argument that the defendant should be subject to general jurisdiction because he was receiving the benefits of the state's resources, assuming that while he was in California, if he had need of it, he would have received the help of the police and the fire department and medical professionals while he was present in the state. The majority opinion sort of rejects that analysis because it kind of, you get chased down the rabbit hole of, well, how long was he in the state? And he was in here for 2 days, but what about if he was in the state for 15 minutes? Or, what if he could avail himself of the police protection of the state, but not the fire or any other protection of the state? So the majority rejects that kind of analysis in favor of just a pure, if you're present in the state and you are properly served within the state, that's all it takes to confer general jurisdiction. So those are situations where the court can force its jurisdiction over a defendant. There are situations where the defendant can consent to jurisdiction or be held to have consented to jurisdiction, even if the defendant does not believe or know that they've consented to jurisdiction. Typically what happens, this happens one of two ways. It can happen where the lawsuit is brought against the defendant. The defendant is served with process in his home state, but not the forum state. And then the defendant decides that he is not going to contest jurisdiction. He's going to go ahead and just submit to jurisdiction with that forum state. Federal Rule of Civil Procedure, you can look at Rule 12. These are a number of defenses that are brought. Rule 12H1 states that if you are going to contest personal jurisdiction in a case, that you have to raise that immediately with your first pleading in the case, otherwise it's waived. So that's the situation where either you can consent to jurisdiction, or if you don't consent, you have to challenge it right away. The other way that this commonly comes up is that the defendant has knowingly or unknowingly consented to jurisdiction in the nature of a contract, has signed a contract, and somewhere in the contract it says that the defendant consents to jurisdiction in a particular case. These are called forum selection clauses, and it gives the defendants a little predictability as to when lawsuits are going to be brought, where they're going to be brought, what law is going to apply, things like that. So we'll look at this national equipment rental case. I'm going to call it the national equipment rental case because I can't pronounce the defendant's name in the case. So we'll just call it the national equipment rental case. The defendant signed a contract for renting farm equipment. The contract had a clause naming a New York resident as agent for service of process. A lawsuit was filed. The agent was properly served with process, and she gave the defendants actual notice. So she was served with process and passed that on to the defendants. So the defendants challenged the consent to jurisdiction anyway, saying that they didn't consent to jurisdiction in the state of New York. The Supreme Court held that the language in the contract amounted to a consent by the defendants to be sued in the state and to be subject to jurisdiction there. Now let's look at another case that's a little more egregious. You would think that when you affirmatively sign a contract with somebody and you read the contract and it says that you consent to bring any lawsuits related to the contract in the state of Florida, that's something you should be held to as with any other clause of the contract. However, let's look at something that's probably a little more common these days, and this is the Carnival Cruise Lines case. This is a case where the plaintiffs bought a cruise ticket from their Washington-based travel agent. They went to their travel agent in Washington, paid the travel agent money. The travel agent then forwarded the money on to Carnival Cruise Lines and procured a ticket for a cruise. The tickets included a clause on the face of them that said that, instructed the holder of the ticket to read the contract, and the contract that was part of the ticket contained a forum selection clause consenting to jurisdiction in the state of Florida. The cruise, I think, left from Mexico and returned, and during the cruise in international waters, a plaintiff slipped and fell on one of the decks and was injured. She went back home to the state of Washington and filed a lawsuit there. And Carnival Cruise Lines moved to dismiss the case because the contract between them that was part of the ticket said that all the cases must be brought in the state of Florida. So the issue here is, does the forum selection clause incorporated into a commercial cruise ticket act as a consent to jurisdiction? Now, in this case, we might not look at a commercial cruise ticket, or these days it would be an airline ticket or bus ticket or train ticket, anything like that. You don't really look at that as a contract, although it is. You wouldn't think that you'd be able to take, if I flew on Southwest Airlines, and they said that we must bring all lawsuits in the state of Texas, that I could go up to my Southwest Airlines gate agent and I can haggle with them over the terms of that contract and say, look, I'm going to buy a ticket from you, but I'm not going to consent to lawsuits being brought in the state of Texas. I want to bring it in my home state. That's not something we would do. So even though it's not a clause that you would typically argue over or be able to sufficiently negotiate on your own, when you buy the ticket, you use the ticket, and it contains that clause, you are deemed to have consented to that clause being there and consented to jurisdiction in that forum. So the rule from the Carnival Cruise Lines case is that a valid forum selection clause in a routine boilerplate cruise ticket can create a consented jurisdiction in the forum state. And the court looked at, whether there was any evidence of fraud or overreaching, or any evidence that the forum was chosen only to discourage cruise passengers from pursuing legitimate claims. If I were operating a business in the state of Illinois and all my customers were local and I signed contracts with them, and the contract said all lawsuits that must be brought in the state of Alaska, and I cannot, I can't say, get the court to enforce that, because there's no connection that I have there. It's clearly I'm doing that to prevent people from bringing reasonable claims against me, because it would just be too onerous to bring a case in Alaska when all my connections are are in the state of Illinois. So the court looked at this and said, look, there's no fraud here. There's no discouragement from pursuing legitimate claims. Carnival Cruise Lines is based in Florida. They have many of its cruises depart from Florida. Plaintiffs were aware of the clause. There was no evidence of fraud. So the court held that the forum selection clause would be enforced, and the state of Florida would have jurisdiction over the case. So moving on, let's talk about notice. We've sort of talked about it a little bit. All the issues with personal jurisdiction, in rem, quasi in rem, and in personam jurisdiction, general or specific jurisdiction, all of this really boils down to an issue of notice. We're looking at this from the standpoint of does due process allow for the defendant to have sufficient notice of the claims pending against him in the forum state, sufficient to confer jurisdiction? So we looked at in Pennoyer, the court talked about, the defendant has property within the state, but the property wasn't attached prior to the judgment being entered, it wasn't attached at the beginning of the lawsuit, and therefore the defendant likely would not have had any notice that the action was pending against him. Same with specific jurisdiction. You have specific contacts within the state, and when the court then brings an action against you, related to those contacts, you have notice of that lawsuit being brought against you. General jurisdiction as well. You're at home in that state. You live in that state, and so it's deemed that you likely will have notice of the claims brought against you by the exercise of the jurisdiction of that court. So this is actual notice of a lawsuit being filed against you. And this is the typical procedure is the plaintiff goes to the courthouse, files a lawsuit, either the county sheriff or a private process server will then take the court summons and a copy of that lawsuit and go physically deliver it to the defendant or representative of the defendant, and that will be deemed a personal service. Now, it's possible to file a lawsuit in one state and serve a defendant in another state. Depending on the law, you can file a lawsuit in one state and serve a defendant internationally. But the notice requirement is that the defendant must receive notice of the suit and what the suit is about for due process to be satisfied. So the central case in notice is the Mulaney versus Central Hanover Bank and Trust Company case. And this is a really complicated case involving what are called common trust funds. And the quick breakdown of this is that there are a lot of individual trust funds and individual estates, probate estates, and New York law allowed those to all be pooled in a common fund for purposes of administration and investment. So where one person who had a small estate may not be able to reap all the benefits of having their assets invested in a particular fund or having someone administer the estate. All of these people can be pooled together, and then all those assets can be invested into a particular fund or administered in a particular way, and then the funds later on would then be redistributed out back to the individual trusts or estates and their beneficiaries. So this is a case where there was a common trust established in New York. The money was all pooled together for the common trust funds, and after the first year, the trustee of the trust filed an action to distribute the money back out to the trusts. Pursuant to the New York statute, the trustee, and I put this in quotes, served the appellants with process by publication of notice in a local newspaper. Some of the appellants some of the beneficiaries were from New York, but some were clearly not from New York. And the New York statute basically stated that publication is a sufficient means to put the beneficiaries on notice. So the notice that was published in a local newspaper was published once a week for 4 weeks, and the notice only included the name and address of the common trust fund and the names of the participating trusts and estates. So the beneficiaries, who were the appellants, were not listed by name. So you can sort of look at this like this is not a state where you live. This is a local newspaper, and for once a week for 4 weeks, they published a little notice in the back of the newspaper that said, to anybody who is concerned, this is the name of the common trust fund. The assets are subject to distribution. These are the beneficiary individual trusts, and putting you on notice that this is going to happen. If you don't live in the state, and the court looked at this as if you don't live in the state and uh, you live outside the paper's normal jurisdiction or circulation, there's almost no chance you're going to see that. So the issue here was, does the publication in this local newspaper give the out-of-state beneficiary sufficient notice to satisfy due process? The rule here is that in an in personam case, personal service of process on the individual is needed to give proper notice. So in an action against the person, when there's sufficient jurisdiction over the person, not just their particular property within the state, which this was not an action on property, this was an action in personam, that there has to be personal service of process on the individuals. The court also said that the personal service of written notice within the jurisdiction is a classic form of notice, always adequate in any type of proceeding. The fundamental requisite of due process of law is the opportunity to be heard. The elementary and fundamental requirement of due process in any proceeding which is accorded finality is notice reasonably calculated, under all the circumstances, to apprise interested parties of the pendency of the action and accord them an opportunity to present their objections. So essentially, proper notice is service of written notice and the opportunity to be heard. So the court looked at the rule and did not say that constructive service, which is what service by publication would be, you're deemed served even though you're not actually physically served with process. So the court did not rule that that was per se insufficient under due process, but it did hold that in this case the service by publication was insufficient to satisfy due process. Publication in a local newspaper is highly unlikely to be seen by anybody out of state who resides outside of the normal circulation of the paper. And this is multiplied when the notice doesn't even contain the name of the party to be served. So the court also held that notice by publication can accompany other traditional forms of notice, such as attachment to real or personal property located in the state, or in situations where you have missing persons or unknown persons who may be parties to a suit, that publication may be the only available means. But in this case, the court held that the New York law was unconstitutional. It didn't provide adequate notice for due process, that the trust company needed to try to personally contact the beneficiaries and give them actual notice of the action. So the last thing we're going to talk about this week is going to be limits on jurisdiction, and all of these topics, and I know I'm going through this at a relatively brisk pace. So all of these topics you're going to read about in more detail in your book and when you're doing your exercises this week. These are all very complicated topics. So we may talk about one case for each one, or a couple of the general rules that are gleaned from each of these cases. But when you get into this in litigation, there are numerous cases out there. You could read hundreds of cases that talks about all the intricacies and all the myriad fact patterns that talk about jurisdiction or venue or forum nonconvenience. And so essentially what we're doing here is giving you a taste of what the issues are and putting you on notice that these could be issues in lawsuits, and then it's going to be up to you then as you go forward in your careers to really do substantial research, and if you have these issues come up, be able to really analyze them and look up what the different intricate rules are. So we're going to talk about limits on jurisdiction. The first one we're going to talk about are state statutes on long-arm jurisdiction. And long-arm jurisdiction is when the state exercises jurisdiction over a defendant that's not in the state. So it's just a state exercising jurisdiction over non-resident defendants. And the state can pass a statute called a long-arm statute, where the state can limit its own jurisdiction over non-resident defendants. What you'll see mostly now is what the California Code of Civil Procedure states in Section 410.10 is a court of this state may exercise jurisdiction on any basis not inconsistent with the Constitution of this state or of the United States. So essentially that states that the state court can have jurisdiction over a non-resident to the fullest extent of the law that's not inconsistent with due process under the Constitution. So let's look at the Gibbons versus Brown case. This is a Florida appellate court case from 1998. So to do this analysis, for a state to exercise jurisdiction over a non-resident defendant, you have to make a two-pronged analysis. One, the plaintiff must allege sufficient jurisdictional facts to bring the defendant within the coverage of the long-arm statute. So you have to look up the long-arm statute, and then you have to allege sufficient facts to bring the defendant within the coverage of the long-arm statute. And then, if the long-arm statute applies, you have to look at whether the defendant has sufficient minimum contacts with the forum state such that the exercise of long-arm jurisdiction does not violate due process. So does the long-arm statute apply, and does asserting jurisdiction here violate due process? In the Gibbons case, the non-resident party was bringing an action in a Florida court, and essentially what happened here is that there was a car accident in another jurisdiction. That one party sued the other in Florida, and then a few years later, after the action was over, the opposite party sued them. So there was a couple of lawsuits that were cross each other, but the second lawsuit is the one that's at issue here in Gibbons versus Brown. And it essentially said that, look, because the defendant in this case was the plaintiff in a previous case, and as the plaintiff in a previous case, she filed a lawsuit here in Florida, and because she has availed herself of the courts of the state of Florida, she has made herself subject to the long-arm jurisdiction statute. And the court basically said, look, that original case was over before this case started. Just because a non-resident defendant avails himself of the jurisdiction of the state of Florida and bringing one lawsuit does not mean that the court said is the veritable sword of Damocles hanging over the head of that party for the rest of their existence. If I bring a lawsuit in Florida and then the lawsuit is over, then 5 years later someone decides to sue me, can they sue me in Florida based on the fact that I had previously had a case in Florida? No, the court here says that you can't base jurisdiction solely on the fact that the person has previously filed a lawsuit in that forum state. So venue is a very important thing that we will discuss, and it's similar. It sounds similar to jurisdiction. It is different though. So jurisdiction is the power of the state court or the federal courts to assert their power over a defendant. Venue is more narrowly tailored. A court can have jurisdiction, but then when there's multiple courts within the state or within the federal district court system, which of those courts should the action be properly brought in? So we can look at this in the state of California, that the state of California may have jurisdiction over me as a defendant, but venue may not properly lie, let's say, in Los Angeles County. Perhaps that the lawsuit should be brought in a different county court, or in the federal court. I may have jurisdiction in the state of California, but the Northern District of California is a wrong court to bring it in. It should be brought in the Eastern District. So that's what we're looking at with the issue of venue, and this is 28 U.S.C. 1391. This is the general venue statute. So venue, the civil action may be brought in a judicial district in which any defendant resides, if all defendants are residents of the state in which the district is located. So if all the defendants are residents of the state, the case can be brought in any district in which any defendant resides. So this is obviously the federal jurisdiction statute. So we'll use my home state of Illinois. If all the defendants are residents of Illinois, then and one of the defendants happens to reside in the Southern District of Illinois, well, then there's proper venue against all defendants in the Southern District of Illinois. Okay, the second prong of venue is the civil action can be brought in a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of the property that is the subject of the action is situated. So this is, you can look at this as in a tort case where the tort occurred, in a property case where the property is located. So that's the court that would have proper venue in those cases. And the last one is if there's no district in which an action may otherwise be brought as provided in this section, the case can be brought in any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. So if there's no other district in which the case can be brought, then the case can be brought against wherever the defendant is subject to personal jurisdiction, which is usually wherever the defendant may be found. So we'll look at the DK Enterprises case. The plaintiff sued a number of international companies for price fixing. This was under the Clayton Act. This was a federal case. The Clayton Act allowed for exercise of worldwide jurisdiction and service of process. So these, I believe, the case was brought against an Indonesian company. The service of process was actually personally affected in Indonesia against the company. So the court found the jurisdiction was proper when the case was brought in the Eastern District of Virginia. But then the court had to look at and see whether the venue was proper. Should the case be brought in the Eastern District of Virginia versus the Western District of Virginia? Because the court properly found jurisdiction in Virginia. So if we look at Section 1391, the court held that the venue is proper against a foreign company where it does business or it can be found, or if neither of those apply, in any district. And that's for a foreign company that's not an American company. The venue against American defendants is proper where any one of them may be found. So in this case, there was some alleged connection to companies doing business in the Eastern District of Virginia, and the court wasn't exactly clear on those facts, so it remanded the case for a determination of whether the venue is proper in the Eastern District of Virginia or the Western District. But when you have a company that is a foreign company and jurisdiction is proper, then you bring a lawsuit where the company can be found or where it does business, or in this case, because it didn't do either of those in the state of Virginia, in any district within the jurisdiction. The next issue I want to discuss with you is the issue of forum non-conveniens, or shortened to just FNC. And it's related to venue. Under 1404A, the court, for the convenience of the parties, can transfer a case from one venue to another court that has proper venue for the convenience of the parties. So in these cases, the court looks at the factors and says, okay, well, we have jurisdiction, and venue is proper here. Venue may also be proper in another venue within the jurisdiction, but we should transfer the case because it would be more convenient for the parties and for everybody involved if the case were brought in that venue versus the one it was actually brought in. And there are a lot of factors that go into this, and we'll talk about one case and the factors, and then again you'll see that there are just myriad of cases out there that talk about each of the individual factors and how to weigh each one, and it's a pretty complicated issue, but you can get into that when you have one of these issues come up. So the Piper aircraft case, there was a small plane carrying Scottish passengers that crashed in Scotland, killing all aboard. The plane was made by Piper in Pennsylvania, and it was operated by a UK company operating in Scotland. The lawsuit was brought in California, and the defendants sought a transfer to Pennsylvania, where the defendant Piper was operating under the doctrine of forum non-conveniens. So the court applies the rule that The case is only going to be transferred to the new venue when what are called the public and private interest factors clearly point toward the new venue. So let's talk about what some of those factors are. So first and foremost, the plaintiff's choice of forum, where the plaintiff decides to sue, is given the greatest deference when the plaintiff has chosen his or her home forum. So if the plaintiff is from the state of California and brings this lawsuit in the state of California, well, then the courts are going to give that a lot of deference because it's assumed that the plaintiff has brought the lawsuit where it's convenient for the plaintiff to be. And sometimes that's not the case. But as a defendant, if the plaintiff sues in the plaintiff's own home state, it's hard to argue that that's an inconvenient forum. However, when you have a foreign defendant, or I'm sorry, a foreign plaintiff, or a plaintiff suing in a foreign forum that's not the home forum, that choice of forum is given less deference. So if I'm a California resident, but I decide to bring a lawsuit against a company in North Carolina, my choice of North Carolina as a forum is given a lot less deference to the court than it would have been if I had chosen to brought the suit in California. So we have to look at the public interest factors and private interest factors. So the private interest factors are the relative ease of access to sources of proof. What's the access to the evidence here? Where are the documents located? If there was a tort, where's the crash site? Where's the airplane? The availability of compulsory process for the attendance of unwilling witnesses. So again, where are the witnesses located? Can we use compulsory process to make them show up to a deposition or to court? And sometimes you'll see this in, there are witnesses scattered all over the country. So, if I bring a lawsuit in California and there are some witnesses located, in Colorado, can California exercise compulsory process for making those witnesses show up to California? No, they can't. Um, the possibility of viewing the scene if appropriate to the action, in this case, in the Piper case, would it be possible for the jurors or the court to view the scene of the accident, and any other practical matters that make the trial easy, expeditious, and inexpensive. So those are private interest factors. Those are private to the specific parties and witnesses involved in the case. The public interest factors involve a broader interest of the public at large. The administrative difficulties of the courts. Sometimes if the chosen forum is a heavy-duty court that's very backlogged and has a long time to get from filing to trial, but the possible court that the case can be transferred to doesn't have those issues, sometimes the court will let it go to the new jurisdiction just because it would be in the interest of the parties to have the case decided more quickly. Another public interest factor, the interest in having local controversies adjudicated at home. So if this is a case that's involving, a Pennsylvania company or an accident that occurred in Pennsylvania, there's an interest in having a local controversy like that decided by a Pennsylvania court versus having that decided by a court all the way on the other side of the country. The interest in having a trial in a forum that's familiar with the law governing the action. So sometimes you'll have a different law that applies to the action versus where the court is sitting. So if this is a case where the California court has determined that Pennsylvania law should apply, then there's an interest that having a court that's more familiar with Pennsylvania law, assuming that would be the Pennsylvania court, the action should be brought there instead of in a California court who's not familiar with Pennsylvania law, but then would have to try to apply Pennsylvania law to the facts. The avoidance of unnecessary problems and conflicts of law or application of foreign law. Again, there would be an issue of what the law in California and Pennsylvania could conflict with each other, or one would have to apply the foreign law, and that would be kind of a burden. And then the unfairness of burdening citizens in an unrelated forum with jury duty. And I can tell you this from my own personal experience. I practice mostly in Illinois and Missouri, but also in California. But we have lawsuits brought from plaintiffs who are all over the country in this small county in Illinois, just on the other side of the river from St. Louis. And one of the issues that we consistently argue, although in that jurisdiction we tend to lose that argument, but one of the arguments is that the jury pool of this small county in Illinois shouldn't be burdened with having to decide the lawsuits brought by these plaintiffs from all over the country. They should bring those lawsuits in their own home forum and let local juries decide those issues. Okay, so that concludes the material for this week. I know it was a lot of material, and there are a lot of complicated issues involved, but I'm going to leave that to you to parse out in your assignments and in your various activities you're going to do this week. We talked about general jurisdiction, which is different than the specific jurisdiction we talked about last week. We talked about the proper notice the defendant must get to put them on notice that the action is pending against them. We talked about the different limitations on jurisdiction, the state long-arm statutes that allow states to exercise jurisdiction over foreign defendants, venue, which is when a particular forum state or the United States has jurisdiction, and then what particular county court or federal district court would the case be properly brought in. And then forum non-conveniens, when you have proper venue and you have proper jurisdiction, but there's a more convenient forum that serves the private and public interest factors for all the parties involved, then the court will send that there. So please let me know if you have any questions about any of the material this week. Next week we will get started on subject matter jurisdiction, which is another very weighty issue in civil procedure. If you have any questions or comments, please feel free to shoot me an email or give me a phone call. Thank you.